So you've heard from a patent lawyer, now you're going to hear from a franchising and distribution lawyer. I'm going to introduce you to Peter Silverman. He's a franchising and distribution lawyer, commercial litigator, a mediator, and an arbitrator with the Shoemaker, Loop, and Kendrick in their office in Toledo, Ohio. I could go on about his long and distinguished career, but most relevant to us today is that he is a founder and trustee of the Early Dispute Resolution Institute, EDRI. EDRI has developed a process, a set of guidelines to help resolve disputes as early as possible before lots of money is spent on litigating and damage done to relationships. So I attended an EDRI training a bit more than a year ago and was immediately impressed with the potential. It's simple, it's clear, and it's powerful. And if you've been to other sessions here at EarthX in the last few days, there's been a lot said about a sense of urgency to get projects developed, to get technology deployed, to move markets, and to make change. And as that last excellent session told you, there is plenty of potential for dispute when trying to do that. So getting those behind us quickly can be a really good thing. So I'm hoping with this talk you will be impressed and inspired to try these tools and to use them to get disputes resolved faster and get on to implementing that progress. So with that, I give you Peter Silverman.
Thank you. So this is a whole new approach to dispute resolution. And it's going to be rolled out nationally in a little more than a week. So you're getting a sneak preview of what's going to happen. I call it the 30-day lawsuit, ending litigation before it begins. And I'll add a caveat that 30 days is what happens in a normal commercial dispute. We'll talk about how the process would apply in a more complex dispute. Nathan's going to talk about how it might apply in a circle of litigation that obviously, if you start early, you're not going to resolve in 30 days. Okay, so we think about it how a CEO looks at this. CEOs don't like litigation, right? They're expensive, disruptive, and lengthy. So the CEO sends a memo to general counsel, your outside counsel, and says, simplify what's at issue, get the information you need to analyze the risk, and give me the numbers. So from a CEO's perspective, the CEO wants to make a decision just like any other business decision. Tell me the risk, give me the numbers, and if we can resolve it on a reasonable risk-informed basis, do it. I think this is how most CEOs view litigation. We as lawyers come in and say, well, you know, we need discovery, I gotta look at everything, we've gotta develop the risks over time, and at some point I'll come and tell you when it can be resolved. That, for some reason, businesses have accepted that. So mediation came in the 80s, and mediation generally occurs toward the end, and for whatever reason, business owners have accepted that, whereas everything else in business is speed, decisions. So this is a new way to look at dispute resolution. It's called EDR mediation, and I'm going to talk about the AAA is rolling it out nationally, and I'll talk about how they're going to do it, but it's a process, not an event. If any of you, traditional mediation, not necessarily in an environmental context, but a traditional commercial mediation is you submit mediation briefs, and then you have a one-day mediation, and you screw around for about 6 or 7 hours, just playing games, and then about 4 o'clock you start discussing settlement, and by 11 o'clock you'll either know whether you've settled or not. Now, that is a pretty crazy way to resolve disputes, but that's how lawyers have been doing it now for close to 40 years. So this is a process. It starts early, typically should take no longer than 30 days. It's facilitated by a trained EDR mediator. So the EDR Institute trains mediators in this. It's a 2-day training. The bulk of the training is on risk analysis, decision trees, and probability. The process involves initial exchange of sufficient information, which we'll talk about. Sufficient information is what you need to analyze the risk. There's a rigorous risk analysis process, and then negotiation is based on a risk-informed negotiation resolution, as opposed to positional bargaining and the nonsense we usually go through as lawyers. So here was the foundational question. And I'm going to ask you each to write down numbers here. There's going to be 3 numbers you write down. So this is in a field you're comfortable with. And the problem comes in to you, and the client comes in, and the client says, here's the dispute, here's the contract, here's a few of the key emails. I've talked to my quality control director, and this is what she says about it. And we got a couple problems, but we should win the case. So based on this information in a field you know, how confident are you that you can predict the outcome of the case within plus or minus 20%? Write down a number. Don't overthink it. This is intuition. Next, you call back to the client and you say, you know, I need a few more things. Send me a couple documents, some emails. I need to talk to your QC director, and you have that. And then you call the opposing lawyer, and the opposing lawyer says, oh, here's the other side of the story. How confident are you at this stage that you can predict the outcome within plus or minus 20%? Last, you spend 2 years. Your law firm makes $1.5 million. You've done discovery, depositions, Nathan's favorite, which is e-discovery, and massive databases. You both filed for summary judgment, which you both know you're going to lose because it's a factual dispute, but you want to let the judge know what a good case you have. You get that result, and you're getting ready for trial. How confident are you at that stage that you can predict the outcome within plus or minus 20%? If you can write down that number. And typically, in many cases, this is when mediation happens, right? That when is the case ready for mediation? Oh, after discovery, maybe after motions. So we initially gave this survey to 140 lawyers in an ABA forum to get some kind of specialty and a range of responses. And these are the average numbers when we added everybody up. Now, some people, for me, when I'm getting ready for trial, I have lost all perspective on the case. I am so in the weeds that if somebody says to me what's going to happen, I'll say, well, let me get into it for a couple days. I don't know anything. And so my number in this second is I've got a pretty good idea of what's going to happen. Anybody here I want to comment on these numbers, or whether you think these numbers look to you like intuitively correct? Any thoughts? Somebody's got to have a thought on this. Yeah.
You go through a lot of work to get 7% more certainty.
Yes.
Does it work?
Yes. Right. So, and that's 7%. But right here, you're a month into the case. And if you tell your CEO, write a check for $1.5 million, sit through depositions, go through all the disruption for a couple years, and I'll be able to give you the same level of confidence on resolution as I was after 2 weeks. CEO is going to say, are you crazy? Hey, let's do it now. So this was the key. This was my intuition, and so we did this survey. It's only with 140 lawyers. This is a new field. I'm hoping people try and duplicate this and see what it is. It accords with my intuition, but people do have different ways of coming at it. Okay, so the American Bar Association in 2024 came out with a resolution encouraging all lawyers to use informed and voluntary use of early dispute resolution. I personally think this is going to become an ethical obligation, that you're going to have an ethical obligation to go to your client and say, I can try and resolve this now. Here's what happens, or we can go through the standard trial and then dispute after discovery. The ABA, so I've been working on this for 20 years, and for 15 years, everybody told me I was crazy. But about 5 years ago, the American Arbitration Association saw the idea, liked it, and we've now trained a panel of 15 mediators on the process. So there'll be a specialty panel. If anybody files for arbitration with the AAA now, you will get an invitation to do this process. And the idea is you can do this process within the time it takes to start picking the arbitrator. So there's no delay in arbitration. And you can go ahead with this. And that'll actually start, May 4th is a Monday. So what we have is called EDR mediation guidelines. And if you go on the Institute's website, you can see them. But it's a comprehensive set of guidelines. Now, when you read them, it's a little intimidating. It looks like, federal rules or whatever, but the process, they're guidelines, they're not rules. And what we teach the mediators is how to be flexible in using them, because it's supposed to go quickly. And I will give you an idea of how it actually works. So the AAA, if you go on, usually they have mediation rules and arbitration rules. They won't have that for this. It'll be standard mediation rules, but they will refer people to the guidelines if people want more information. What we tried to do is incorporate, this is another problem with the legal section, is that we don't innovate, we respond. And all through business, everybody's taking the latest developments and applying it. We haven't as lawyers as much, and so we tried to incorporate theory, for overcoming biases, negotiation theory, probabilistic thinking, advanced risk analysis, forecasting, and decision analysis. Now, most groups I talk to went to law school because they can't do math. So this group will be different. My guess is most of you can do math. But this is one of the things that will need to be taught and learned. So what's the ethics? If you're going to do this process, you have to have informed consent from your client. You've got to be able to explain it to them. The whole idea is client self-determination, putting risks in a form that businesses can make decisions. Oops, go back here. Both parties have to agree in good faith to seek early resolution on a risk-informed basis. If you don't have two sides who are willing to do that, the process doesn't work. And then self-determination. The client has to have sufficient information to make an informed settlement decision. So the key is sufficient information, not the total information that you're going to have after discovery and summary judgment. So what's the process? Oops. There's 4 steps, and I'll just go through them quickly. Oh, I'm going to take my phone out so I can keep track of time here. So what happens when someone calls me, one, you've got to know your case as a lawyer. Lots of lawyers don't want to put in the time early, right? You put in enough time to do the complaint. Or if you're a respondent, your immediate thought when you get a complaint is, all right, I'll get 60 days, and then I'll have an answer, and we'll go through the answer, and you spend weeks trying to figure out how to deny everything, right? And as very carefully as you can. But here, the idea is you would go in understanding your case because you're going to advise your client on settlement at this point. I say to parties, send me the key documents. Originally, when I started this, I thought people would inundate you with documents. They don't. It's, when you get to trial, right, you're going to say to your jury or the judge, here's Exhibit 27. I know we've looked at this 6 times before, but blah, 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 blah. That's what I get, that exhibit that you're going to look at 6 times before. And with that, I understand the case. And the key is to understand it at a simple level. Because if you get into all the complexities, all the different ways to plead a case, your affirmative defenses, you're lost in the weeds. And your CEOs, right? The CEO wants a 1-pager. And the 1-pager, you've got to say, this suit is about X. You could think about when you're talking to the jury, in your opening statement, you might say, this case is about X. X would be your simple part of the case, what the story is going to be. In that first call, I say to people, do you need any information from the other side? Now, if you see, look in the guidelines, this is a long section in the guidelines. So when we started this, I assumed every lawyer was going to try and give me their kitchen sink discovery. Say, oh yeah, I've got to see all these things. What I've realized now is on that call, I say, do you need to see any information from the other side? I'd say half the time, both the lawyers say no. I know enough to proceed in this. Oftentimes, plaintiffs have to put more in on damages. But if they do need to see documents, both lawyers know exactly what the other side needs to see. And so if you're good, and when this is how we train people, is both lawyers will agree, okay, I'm going to produce this, you're going to produce that. And I ask people to do it in a week. Can you get it done in a week? Now, there's a more formal way to do it where you submit written requests and then the mediator tries to narrow it to this sufficient information. What do you need to analyze risk? You can question witnesses in this. So it's very rare it's used in a fraud case. A plaintiff might say, I would like the defendant to question my witness because they think the witness is very credible. So why don't you just ask them about it? Or a defendant might want to do it in a fraud case to see how the witness stands up. It's not cross-examination. You might ask the mediator to ask the questions, but the idea is just to get information. And since it's within a mediation context, you don't need to worry about preparing your witness and everything, because the idea is to persuade the other party. So you want your witness to just be natural. Experts. Most cases that we have, and not the complex kind of cases that were discussed about before, but most cases we know we could write our expert report, right? We call an expert and we say, hypothetically, this is the situation, A, B, C, and D. Meets the standard, you say, great, I'll hire you. If the expert says, boy, I don't think that meets the standard, I need to see more, you say, thank you very much, I'll get back to you. And then you call the next expert, right? So we all know in most cases what our expert is going to say. And if you do need an expert, though, there's provisions on what we call EDR experts, where the expert can give you an opinion, a short-form opinion, without prejudice. That's right, the expert's not going to look at everything, not going to write a full report, but they're going to give you a summary of their findings, and the expert's not held to that, because when they do a full report, if it goes that far, they may come to different conclusions. Or you can hire joint experts. So I had a case which was a national recall of refrigerators, because the ice machine had a part that failed and resulted in the ice melting, and so tens of thousands of homes and apartments got all this water damage. And the dispute was between the supplier and the manufacturer. Were the specs wrong, or did the supplier provide the wrong product? And so we hired an expert. Both sides worked with the expert, and the expert ran a 60-day test on part failure and came up with a conclusion to resolve the case. Originally, I thought the verification was going to be a problem. How can you trust the other side's going to give you that? But then I realized in normal discovery, you have to trust the other side, right? Occasionally, somebody will hide something and you'll find it, but I think in most good firms, you're going to produce everything. And here, I've never had to use verification, but there's a process where each side can certify they made a good faith search and response. Risk analysis is what's new in this. And so the idea is to quantify risk, again, so you can give your client the business information they need. And the first two steps become important. If you've simplified the case in step one and each side has sufficient information, you should be able to do a rigorous risk analysis. The mindset has to change. So, has anybody read the Soldier Scout book? I forget its name now. It's I don't remember the name. It's a great book on mindsets of a soldier and a scout. The idea of a mindset of a soldier is what most lawyers are like. We're defensive. We stick to our position. We're out to win, and that's how we view disputes. The scout mindset is we try to draw a very accurate map. And if somebody raises an error, we say, thank you very much, and we change the map. So it's not a battle. So the process is designed to move people from soldier to scout. And then type 1 and type 2 thinking. At the beginning of a dispute, there's no trust. You've listened to your own people for however long it took before you got to this stage. And so you've gotten a certain framework in which you're putting it, and so your reactions are immediate and intuitive, and they're biased. Both sides are very overconfident. The process, by taking people step by step and doing the risk analysis, tries to move them to type 2 thinking, slow, not emotional, rigorous thinking. There's actually a lot of work out now in type 3 thinking, that the rational process is as deceiving as the emotional process. And what you really need to do is you've got to bring your intuition back in, and that's type 3 thinking. So the other key change is to move from positional bargaining. Your patent's invalid, and we're going to win, etc. And maybe we'll compromise. And both sides take rigorous positions. And for your clients, that doesn't help them at all. right? The client knows, if the client knows that a business decision is going to make them a lot of money and they're 100% certain they're going to do it. But what businesses do is they'll do expected value calculations. What's the probability this happens? Why are you thinking that? What are the risks? And they put it in a matrix, and they use the matrix to help them think whether it's a wise business investment. To do this, here's what lawyers say and what clients hear. So a lawyer will say we have a strong case, and the lawyer's going to mean it's pretty good, but the client's hearing, okay, this is a winner. If the lawyer says this is a tough case, client's going to hear, okay, we're going to win this, but the lawyer's covering his ass, right? Just in case. We're facing an uphill battle, a lawyer might say, but the client hears, 50-50. Or I like our chances, a client hears it's a slam dunk. There's a complete communication misalignment, and there's a lot of psychology work on this, and it's shocking how different the speaker's views are from the client's views. So here's going to test your math intuition, and you can just, the idea is to test your intuition, because for this room it's probably going to be different, but generally lawyers have no idea what the expected value of a case is. So here there's a 50% chance of winning a case, 33% chance, 100, 200, or 500 damages, and future fees through trial are $75,000. Now, this isn't realistic, right? Who charges $75,000? But it's to try and keep the math simple. 4 choices, and pick the one, obviously the rounded numbers, pick the one that is closest to the expected value, and you can write it down. And the answer is $58,000. So what generally it depends on the room, but most lawyers look at this and they see the damages and 33%, and they say, oh, it's only 50%. So they're looking at the 2, 150, and 100, and maybe they're between 150 and 100, and they're just not thinking about how it really works. But the reason it's much lower is because you're going to spend $75,000 no matter what. If any of you are unfamiliar with the way the decision tree works, at the far left, this is called a chance node. The number under it is the risk-adjusted value. You can either lose the case or win the case. Either way, you're going to spend $75,000 on attorney's fees. And if you win the case, you got damages and the percentages over there. And then after the green triangles, which are called terminal nodes, you have the chances of the different outcomes and the likelihood they'll occur. So here, what generally a plaintiff doesn't think about is 50% of the time they're going to lose $75,000 because they're going to lose and they've spent the money on attorney's fees. And then there's a 33 or 16.7 of each of those. So what this does is it gives the business person a chance to look at this, and it tells you some interesting things. This is a very simplified model, but let's say you're a normal human being. Let's say any of us get sued in a case, and all of a sudden, if you have a 50% chance of losing $75,000, depending on your situation, you could wipe out your savings. And you might just say, there's no way I can take that risk. With a business, there's oftentimes a very low risk of a very catastrophic award. And the question is how much risk are you willing to take in a catastrophic award? And people have different risk tolerances. So you get different numbers, and this 58,000, it's an unusual thing in probability. Probability generally depends on how do you explain it? You say, well, if this case was tried 10 times, the average would be 58,000. Case isn't tried 10 times, it's only tried once. So it's more like a sports game. If anybody bets on sports, games only happen once. But the bookmakers take all the bets in, and what they find is, if this was a sports game, 58,333 would be the betting line, and you could bet over or under it. And what bookmakers seek is half the bets are over and half are under. And so, to a business person, what you would say is, this gives you an idea, a direction of where this case is the likely value of it. If any of you are in litigation funding here, this is an analysis a litigation funder would go through to figure out, if they're doing a lot of cases, they get the advantage of probability because you're investing a lot of times and you know the margin you have to make. So this is a simple analysis. Now the question is, can you do this early with complex cases, like the kind of cases we're talking about? And so what we've done is set it up for a CERCLA case and to see how this might work. Oh, Aristotle. So Aristotle says, our inquiry would be adequately made if it should attain the clarity that accords with the subject matter. It is the mark of an educated man to look for precision in each class of things, just so far as the nature of the subject admits. This thought is how business people are thinking. They don't want to hear blah, 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 this reason, that reason. They say, tell me what you know, tell me what the risks are. I'm going to be relying on you right before trial anyways, so tell me now. And I understand this isn't certainty. So how might this apply in a CERCLA case? And I'm going to hand this over to our esteemed moderator, Nathan Block.
Mic number 2 on? Okay, there we go. So I'm not going to go a whole lot into CERCLA, but I think it was Maeve that made the comment about the wind dispute, that it had been the longest running wind dispute at 12 years. And if you do CERCLA work, I'm not even the slightest bit impressed on the length of your dispute till you get to 25 years. And those are not all that old. These can be really complex, but I don't think they are outside the realm of where you can use the EDR process. You may not be able to do it right at the outset, right? Because sometimes it takes a while to get a basic level of sufficient information. But I've got a couple of examples where fairly early in a dispute, there's a little bit of RI done, remedial investigation, but we don't have a feasibility study, we don't have a remedy, but we've done a back of the envelope estimate. And then 6 years later, after a trial over allocation and EPA selection of a remedy, we find out that we were awfully close, certainly well within the margin of the transaction cost of what we spent. And so they're not perfect, right? But you can, I do believe, in some instances, apply this pretty early in the process, and even if you don't resolve it, make a lot of room. I've got another example where we weren't even trying to pick a number so much. We didn't even at that point know what the remedy was going to cost, but we knew we had to have a percentage allocation amongst the responsible parties. And we spent 3 years bickering with each other in multiple negotiation and multiple mediation sessions over what really ended up being 0.5% between 7 to 10 parties. And we were 100% within the margin of the transaction costs that we spent on that. And I think by using a system like this and by conveying the information in this sort of format, you can help a business leader or a CFO or someone decision maker understand that the prize for continuing to fight may very often not be worth the transaction cost. Thanks, Peter.
Nathan, just quickly on the PRP allocation and whether you can simplify the Gore factors to get a pretty reasonable way to put people in buckets or types. Can you just talk about how you might go about that?
Well, so, particularly early in multi-party circle allocations, you very often have to do an interim allocation to get some money in the hopper and some work getting done. And this process, I think, would be very useful for that, right? Because I'm not looking for surgical precision. As Peter says, I'm trying to get some rough sorting into reasonably sized buckets, and the exchange of essential information shouldn't take all that long in those sorts of circumstances, or very often wouldn't. And if you have parties, again, who are thinking about it in terms of their risk and that risk against the likely transaction cost, I think you can sort into those buckets much more easily than if everyone is coming at it through their own risk lens and through their own information lens, right? Whereas using this process doesn't necessarily make everyone have to agree on how that lens is focused, but everybody's looking at it, or at least has the opportunity to look at it the same way.
So you could use like a volume toxicity matrix or some sort of tool like that for sorting?
Yeah, and it could be anything just from volume in to volume and toxicity. And again, parties are going to disagree on how much more toxic their chocolate is than your peanut butter, but you can, at least figure out what park you're in, right? Am I in a ballpark or am I in Yellowstone? And that really will help in sorting.
Okay. So you've done the risk-informed, you've done the risk analysis, and now you proceed to negotiation. So at this point, what you want is for your client to make a business decision. So rather than the lawyer saying, I think we can do better, I think we can do worse, as a lawyer, your ethical obligation to the client is you say, look, here's the way I see the risks internally for you to make a decision. And that's not your negotiation strategy. Your negotiation strategy is to get as high as you want, but your CEO wants to know, I need to know the risks, and I need to make a decision on whether to resolve. So EDR mediators are trained in this. They're trained in decision trees. They're trained in how to get parties to agree on the simplification of the dispute that you can put into the decision tree analysis. And they'll be able to go to each side and work with each side on this process to reality check each side. And what we found is when we say to lawyers, your goal is to give your client the best information possible, that lawyers do give their client that, because it also covers ourselves, right? So a client can't come back and say, why didn't you tell me after you've lost the case? What happens then in this process is I do this by virtual phone calls, right? So if it takes a week to exchange documents, I work with each side on risk analysis. That might take another week. You start negotiations, and by 30 days, you should have a good idea whether this will resolve or not. And then you can have a formal mediation if need be. And the reason formal mediation works is it's a head-knocking process, right? If you read the ethics of mediation, you're supposed to be a facilitator. Nobody hires a facilitator. People hire head knockers, right? And so it's not consistent with self-determination, but you can use that as the backstop. If an impasse occurs, what happens is you have gone so far into the case, simplified the issues, both sides understand the risks, both sides understand on the issues it's going to pivot on, and you can consider a binding process that would be streamlined. So instead of $1 million arbitration, you might say, look, we know these are the two issues, and we're going to go to the arbitrator and do this. Or we can do it with the judge. Or maybe there's a statutory issue on which the circuits are divided, and you might say, let's go and we'll get a resolution from either the judge or the mediator, and then we're going to return to the process. So by then, even if you haven't resolved it, you have narrowed the issues in the case incredibly. And so here's your options. You can engage a limited discovery on issues causing impasse, re-engage, or you can agree on an expediting process for the litigation or the arbitration. And you might consider an offer of judgment, which is available in federal court and some state courts if you've done enough risk analysis that you're pretty confident on your offer. So what's the secret sauce? In mediation, there's no trust building. Here, there are ethical standards that allow for this trust building and cooperation in the adversarial process. So the psychology is interesting. And the first call, it's all of a sudden the three of us are working together. It's, what do you really need to see? What do you really need to see? Both sides are reasonable. Both sides say, look, I'll pull this together. I'll get it to you within a few days. All of a sudden, you have lawyers cooperating and building trust. The process over time allows for the shift to occur to scout thinking, type 2 thinking, and getting rid of your biases like overconfidence. So you're talking to your client, you're processing new information, you're getting information from the other side, you're getting risk analysis. So by the time you start negotiations, you're thinking about this in a rational way. The key, as I said before, is you got to simplify it initially, and you need sufficient information. I've got a typo in here. I've got it correct. So sufficient information to decide the case, and that is a good way to go about it. Both lawyers recognize it, both clients recognize it, and so they have the confidence to make settlement decisions that will be reasonably fair. And the novel introduction here is the robust application of risk analysis, the basis for valuation and negotiation. And so all the mediators in AAA have gone through not only training, but we went through supplemental training, and everyone had to pass an assessment. So here are the choices. You saw with the session before us, litigation ends up like that. EDR tries to make things simpler. So 10:45, if anyone has questions, or Nathan, is there anything else you wanted to get into?
So I'll kick off with a question, which is,
Right.
Peter, what have you found to be the biggest impediment, roadblock to adoption and utilization? Is there a frequent argument you hear?
The biggest impediment is lousy lawyers. Good lawyers get it. They do. Lousy lawyers say, I'm not going to give free discovery to the other side. You want to say, are you stupid? What you're saying is, I'm not going to charge my client $10,000 for this process and give them information. I'm going to charge my client $350,000 and give them this information. So if you're going to give the information anyways, good lawyers just get it. Lousy lawyers don't. Simplifying a case. Everybody pleads 20 causes of action. Good lawyers know it boils down to one or two key issues. lousy lawyers say, oh, no, this is important, that's important, well, this element of this claim, it could go, and they get hung up. My hope is this gets taught in law schools. I teach it at Ohio State's law school, and lawyers adopt this different mentality to disputes. But right now, the biggest problem is there's a lot of lousy lawyers out there. And this is also threatening to our business model. But it's threatening. There's lots of cases, Cain and Abel, right? That story is as applicable today as it was whenever. There's going to be lots of disputes that go to trial just because of human nature. And all this work for big corporations, and the big surprise is big corporations think the people on top are human beings just like anyone else, emotions and different decisions. So it's not going to threaten, but law firms are going to be looked to for expertise in that. And once a AAA rolls it out and you file for an arbitration, your client's going to say to you, well, what's this about? And people have an obligation to learn it and be competent in it.
Any questions from the audience?
How, for the decision tree or the risk tree, how do you get better at estimating your likelihood of things going one way or the other, or getting a different result?
Yeah, so there is a whole science of forecasting. And if any of you have read like Super Forecasters, anybody read Super Forecasters? So I'll just tell a quick story. Super Forecasters was Tetlock. He found people who were very good at forecasting, and he challenged ARPA. And he said, let's test my people against your domain experts. So you might ask a question like, what do you think the chances are that the Iran regime will be toppled in 75 days? And those types of questions. And the super forecasters beat the domain experts in the federal government. And so they were successful at the super forecasters know how to calibrate. And that is an intuitive process. Now, your clients are going to depend on your judgment intuition before trial to settle. They're going to depend on your judgment intuition early. So it's the same judgment intuition, and there are calibration exercises. We have not done calibration training. That is one of the things we'd like to do. But you can get better. It is a skill. And there's lots of principles to apply. But the big engine's your intuition. Most good lawyers have a pretty good intuition. So what I'll do is I will send parties a 50-50 case. And I'll say, it's usually a more complex treat, but I'll say if it's a 50-50 case, this is what the numbers look like. Most cases are close to 50-50, or they don't get that far.
Grab this one and I'll come back that way.
If any of you, Philip Tetlock, Super Forecasters, and then Nate Silver has a great book called Signal and Noise. Very good on forecasting and expertise in forecasting. Yeah.
So in the decision, when you use the decision tree, is you as the mediator puts it together, or are you suggesting the parties do it and bring their own decision trees? And then I have a follow-up question. What do you see will be the role for artificial intelligence in dispute resolution?
So right now, maybe 0.5% of lawyers could put together a decision tree. So it's just not a skill lawyers have. So the mediator's got to work with the lawyer and the parties. You can ask the parties to estimate their own, and the defendants are going to tell you they have a 75% chance of winning, and the plaintiffs are going to tell you 75% chance of winning. What's helpful, though, is they don't even with that, they haven't thought through how all the risks, if you have a dependent clause, if you've got to pass like a statute of limitations, then win, you've got compounding chances of losing, right? 0.5 losing on statute of limitations, 0.5 on liability, you've got a 25% chance of losing the case. So lawyers haven't thought that through, so the mediator works with them. I don't ask the parties anymore because I know each side's going to tell me 75%. And so I try and find what I think are reasonable numbers and show them this is what it's like at 50%. And I say, if you want to put different numbers in, you can. As mediators, we work with lawyers first, so lawyers aren't embarrassed in front of their clients. But that's what AI is. You can put many problems in AI now, and it's about 90% accurate. The problem is judgment. You have to know this to know if it's making a mistake, and it doesn't have the judgment you have on, if you give it the numbers, this is a likelihood of success, this is a likely damages, it can go through the process. Right now, if you give it a complex problem, there's too much information. You know, when you overload your compute, it makes mistakes. But my guess is within 6 months, it will be able to handle most everything. But you have to know how this works to know if it's wrong and to explain to your client. The numbers itself, although it's shocking how good AI explains like what these numbers mean. It is really shocking how good it is. So that will change things. It'll accelerate this process.
Thank you. So a question for you. The early survey that you showed is pretty powerful because it shows that people's confidence doesn't really rise that much. Do we have any data to show how that changes over time, what the increased information shows us?
No. So I did this survey initially, and I've written a lot about it, and I've always put in the footnotes, I'd love people to start testing this more. No one's taken me up on it. So I tested 140 people. It's pretty good statistical significance, but I don't know if it would replicate, and I don't know what happens. I know with me, occasionally, we all figure we're going to find that smoking gun. How many times do you find that? So for me, I get less confident as the case goes on because I just see more and more complexities. And even the day before trial, you're going to put your witness on direct, you are sweating bullets, right? Because you've worked with her like months on her testimony, and she's going in like, and you just don't know. So that's my intuition.
So there's not really good data for lawyers, but in the decision analysis world, there is really good data on the disparity between the human perception of how much data they need and how much a mathematical model actually needs. And so the decision analysts will actually calculate a value of information, sort of a sensitivity analysis, right? If it costs me $10,000 to improve my model this much, right, is it worth it? And so when you ask the human, right, how much more data do I need, the human always perceives they need between substantially and vastly more than what the model actually needs to make that same increment of actual difference. Any other questions? Mike.
First of all, I was part of it doesn't exist anymore, but Baylor had an LLM program for litigation management. This was one of the main tools they taught us how to do, right?
Oh.
This was an amazing tool. So if you guys get a chance to connect with kind of the professors there on that, they have a lot of background on this. Second of all, there are some free ones out on the internet you can find, right? There's people that write correct. Are there any that you recommend?
Yes.
I know there were back 3-4 years ago when I was in the program.
So right now, this is with a program called Silver Decisions. It's actually out of Poland, but it's mathematicians who put it up. It's open source. It works terrific. There's all kinds of paid decision tree apps. the complexity you don't need. It's more for sophisticated modeling. That here, sophisticated modeling hurts you. It's got to simplify it. But so this is silverdecisions dot. It's whatever Poland's is. But yeah, this works great. There's a woman who's the kind of the expert nationally is named Marjorie Aaron. She's developing her own and should be out, and it'll also be an open source. Yeah.
How do you put the human factor into this? You know, I listened to a very interesting webinar where they said a good lawyer doesn't need a silver tongue, but rather a golden ear. And I've been involved in a lot of big mediations having to do with, you know, big issues, and people fall in love with their data, with the science, but there's so much of the read the room, really start getting the style of the person on the other side, and that can really make the difference in that final resolution?
100%. I mean, you have to use all your standard mediation tools, the personal tools. This just gives you another, it gives you a rigorous application to help it. It also helps on people not getting anchored on numbers, right? You start putting up numbers, if damages are different, if percentages are different, all of a sudden people see a range, they understand sensitivity if things change, and it helps center people, but the judgment is key. That's a type 3 thinking. You can't, this isn't, you're not a cipher. You have to have judgment. Yeah. No, yeah.
I'm sorry, did I have another one over here? This will be the last one, and then we're going to go to a break. There you go, sir.
I have a more like a specific question in terms of how do you handle plaintiff expectations? Like in Texas, when we're dealing, environmental law is very diverse, and sometimes you have plaintiffs that they just want to go for the insurance policies. They don't care about the damages. They use the fact that Texas is so unpredictable in terms of jury verdicts that they know there's always a risk, even if the damages are way lower than the insurance policy. So how do you handle cases when the plaintiff won the entire tower? They say like, okay, you know, damages are $500,000, but you have $5 million in insurance. I want at least half.
So the way that's done is this doesn't guarantee a fair result, what, you know, King Solomon would rule. This gives numbers. So plaintiff's going to come in and says, I want limits. And so for the insurance carrier would come and say, look, here's your risk if you go to trial. Here's your costs that you, plaintiff's firm, are going to spend. Here's how I analyze it and be able to go to the clients. Now, plaintiff's firms, you know, usually don't give a damn about, I don't know if they're plaintiff's lawyers in here, but they usually care, you know, who they picked out their next door neighbor, right, to be the plaintiff. But if you had a rational plaintiff, you know, it's looking at this, the plaintiff might look at it and change. But these would be tools to try to convince the plaintiff's lawyer. So thank you. If anybody wants information on this, you can email me. I'm just a believer in this for the United States and for the good of the bar, and this whole conference is aimed at solving problems. Nathan took the training course, and I was blown away at how he got it and how smart he was in just understanding the whole process.
All right, that's
so you can also reach out to Nathan on this. He's really he's a deep thinker who understands this. Thank you very much.
Thanks, everybody. We're at a break for 15 minutes.